Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, the fallout continues in the state of Oregon as Ballot Measure 114, the worst piece of gun legislation ever drafted in the history of this country, has now passed and is set to become law in the state of Oregon in the very near future. Now, amongst the litany of constitutional violations that this particular ballot measure presents is the new magazine ban. And I believe that this magazine ban was probably sold to the Oregon voter in a package that was not quite accurate. So today, we're going to have to spend a few minutes and talk about what does Oregon's new magazine ban really mean to you? Okay, before we get going down the road we are going down, proud to announce that this class is being brought to you by Legal Heat. That's right, the nation's largest educator of concealed carry classes. Legal Heat has now taught over 200,000 people nationwide since they started doing this in 2005. Now listen, for my Washington viewers, you can find classes at any one of these locations right here. If you're living outside the state of Washington, congratulations, you're probably living much freer than we are, unless of course you live in the state of Oregon. But you too can find a class close to your own backyard by visiting them at mylegalheat.com. That's mylegalheat.com. Now listen, no matter where you're watching, if you find a class and you like it and you want to sign up, go ahead and use the promo code Washington Gun Law. That's Washington Gun Law, all one word, and you will receive 10% off. So for more information, visit them at mylegalheat.com. Okay, so the issue we're talking about today is one component of Oregon Ballot Measure 114, this being the new high-capacity magazine restriction. Now, as a starter, yes, do we understand what magazine restrictions are like here in the state of Washington? We do. We're becoming accustomed to them. However, I'm going to demonstrate that what we are suffering from here in Washington is considerably different than what you are going to be suffering from down there in Oregon, because your magazine ban is far, far different and much, much more restrictive. This is how I'm going to explain this. This here is a 15-round magazine of 9mm. It goes into my everyday carry firearm, a 4-inch barrel. I carry that because it is the firearm that I shoot the best. The standard capacity magazine that comes with that firearm is a 15-round magazine. I can actually and do own some extended magazines that hold 17 rounds. Now, even though our magazine ban, Senate Bill 5078, which was enacted through RCW 9.41.370, went into effect on July 1st of this year, there is nothing unlawful about me owning, possessing, or carrying this magazine because I own this magazine prior to the enactment of the law, which was July 1st of this year. There is nothing unlawful about me using this magazine at the range. There's nothing unlawful about me having this magazine here in my office in front of the camera right now. And there is nothing unlawful about me using this magazine in my everyday carry firearm. The other everyday carry firearm I have that I use sometimes, by the way, has a 12-round magazine. So either one of my two everyday carry firearms exceeds Washington's 10-round magazine capacity. However, I am not in violation of that law because I own those magazines prior and I can use those magazines as I wish. That is not how it works in the state of Oregon. No, 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 no. Au contraire. You see, because your magazine ban is considerably different and far more restrictive. And once Ballot Measure 114 is enacted into law, if you own any of these 15-round magazines that you carry in your everyday carry firearm, well, those days will be coming to an end. Now, just so you understand, Oregon, this is how your new legislation will define large capacity magazine. Large capacity magazine means a fixed or detachable magazine, belt, drum, feed strip, helical feeding device, or similar device, including any such device joined or coupled with another in any manner, or kit with such parts, that has an overall capacity of, or that can be readily restored, changed, or converted to accept more than 10 rounds of ammunition and allows a shooter to keep firing without having to pause to reload, but does not include any of the following. And so here are the only exceptions under Oregon's new definition of high-capacity magazine. The exceptions are A, an ammunition feeding device that has been permanently altered so that it is not capable now or in the future of accepting more than 10 rounds of ammunition. B, an attached tubular device designed to accept and capable of operating only with .22 caliber rimfire ammunition. Or C, a tubular ammunition feeding device that is contained in a lever action firearm. And that are the only exceptions, okay? So for those of you who've been asking about this, and what about that, and what about this? Yeah, I think you can see now that Oregon's law really doesn't have many exceptions. Now, once the law becomes effective, there is a mild grandfathering clause of 180 days, but that's just for licensed gun dealers. If they accept items into inventory and turn around and sell them out of state, or if they have a bunch of inventory and they need to dispose of it, they will have 180 days to do that. Does that 180-day grace period apply to you, the normal average citizen in the state of Oregon? No, it does not. So, unlike my situation where I get to use, possess, conceal carry this magazine as I see fit because I owned it prior to the enactment of the law, Oregonians, you are not going to have the same privilege. As a matter of fact, there's not even exceptions written into the law. No, there are affirmative defenses. And let me point out to you what an affirmative defense is. An affirmative defense is, yeah, I actually committed the act, but I have a legal justification. So the only affirmative defenses that Oregon citizens are going to have to this new magazine ban are as follows. As of the effective date of this 2022 Act, it shall be an affirmative defense, as provided in ORS 166.055, to the unlawful possession, use, and transfer of a large capacity magazine in the state by a person, provided that A, the large capacity magazine was owned by the person before the effective date of this 2022 Act and maintained in the person's control or possession, or B, the possession of a large capacity magazine was obtained by a person who, on or after the effective date of this section, acquired possession of the large capacity magazine by operation of law upon the death of a former owner who was in legal possession of the large capacity magazine. And, okay, and this is critical, okay, because right now, the only affirmative defenses is one, you have to have either possessed the magazine lawfully prior to the enactment of the date or lawfully inherited the magazine by operation of death after the enactment of this law. Of course, the provenance and the proof of that will be placed upon who? The gun owner, that's right. But in addition to having to be one of those two, okay, it either has to be something that you owned ahead of time or something that you lawfully inherited. There's more, because the magazine also has to be A, on the property owned or immediately controlled by the registered owner. B, on the premise of a gun dealer or gunsmith licensed under 18 U.S.C. 923 for the purposes of lawful service or repair. C, while engaging in the legal use of the large capacity magazine at a public or private shooting range or shooting gallery or for recreational activities such as hunting to the extent permitted under state law. And again, when we're looking for what's permitted under state law, once 114 goes into effect, there is no permitted use under state law. So that's one of the most superfluous comments. But there's more to it, because the other affirmative defenses would involve D, while participating in a firearms competition or exhibition, display, or educational project about firearms sponsored, conducted by, approved, or under the auspices of a law enforcement agency or a national or state recognized entity that fosters proficiency in firearms use or promotes firearms education. And then finally, there is one more exception, which is, you can possess a high-capacity magazine if you're going from one of the places that has been previously mentioned in these affirmative defenses. But there's a catch to that, because the law actually reads, while transporting any large capacity magazine in a vehicle to one of the locations authorized in paragraphs CA to CD of this subsection, the large capacity magazine is not inserted into the firearm and is locked in a separate container. So that's right. If you're going to the range because somehow or another you can lawfully shoot your AR with a 30-round PMAG, your PMAG has to be locked away in a separate container from the firearm. So the bottom line is that if I resided in the state of Oregon, I would be able to possess this magazine on my property. And basically anywhere outside of my house, I will not be able to possess, use, or otherwise acquire this magazine. This is far different than in Washington State, where as of today, I just simply cannot go to a store and buy a new 15-round magazine. But any magazine that I have, I continue to own and use as I wish. Oregon, this was sold to you as a simple little fix to your gun violence problem, but this is an absolute abomination of the individual's constitutional, God-given, guaranteed Second Amendment rights. The magazine ban, which was sold to you, you were sold a bill of goods. This has a far, far more restrictive application than you thought. And yeah, is the constitutionality of this questionable? It most certainly is. Oregon folks, I think you probably ought to start studying up on the case of New York Pistol and Rifle Association v. Bruin. Listen, in the meantime, if you have any other questions about Oregon's crazy ballot measure 114, this magazine ban, or anything else related to what's left of our Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.